Welcome to the M&A Alliance Forum. My name is Kyle Griffith. I am the managing partner of the NYBB Group and also the founder of the M&A Alliance. If this is your first time attending a CEO forum or attending any events related to M&A Alliance, we are comprised of an exclusive group of management consultants, business professionals that cover different sectors, different industries, from legal to accounting to mergers and acquisitions to business strategy and so on. So every forum we feature one of our members to provide you with some information that's we hope that's valuable for your day-to-day business. The topic today evolves around employment law and some issues that's going to come about as because of COVID. So today we have a very special guest speaker, which I think is going to talk about a very timely topic. He's a good friend of mine and also one of our founding members of the M&A Alliance. Joining me today is employment law attorney Douglas Rowe. Doug is a partner at Tillman Balin Labor and Law Group. And just a bit of background on Doug. I don't want to steal your thunder, Doug, but I think it's right that I do share with everyone a little bit of information about you and your background. You could fill in the blanks, which I'm sure is going to be a lot of them by the time I'm done here. But for the most part, Doug has a broad range of expertise, including claims and including discrimination, sexual harassment, wage and hour issues, labor, arbitrations. Mr. Rowe is frequently quoted in the media about the Me Too movement and legislation affecting employers and employees. He has developed breakthroughs. He's a seasoned litigator at the state and federal level, and Mr. Rowe was first named to the New York Metro Super Lawyers first in 2011. And he has kept this distinction all the way through to 2019. He's a graduate of Brooklyn Law, and I believe he's an avid golf player. I think you may actually get some swings in today, right, Doug?
I did. Thank you.
Awesome. So, hey, welcome, Doug. I definitely appreciate you taking the time to participate today in this interview. And you mind just sharing everyone a little bit more about your background and your history as an attorney?
Sure. I mean, there is so much more to say, Kyle. But
I know. I don't want to steal all your thunder.
So I've been practicing labor and employment law, representing management for over 30 years. The interesting thing about my practice is that pre-COVID-19, it was essentially a litigation-oriented practice. We got involved in consulting as well, but once the coronavirus hit, courts were essentially shut down or went into a slow mode, and our practice, like most employment lawyers, since then our practice evolved into a consulting practice, whereby at the beginning of the coronavirus, we were involved in layoffs, furloughs, and unemployment issues. Halfway through, not that we're halfway through, who knows when we're going to be through, but after several months, we got involved in PPP forgiveness issues, and now we're actively involved in return to work issues, and that's what I'm going to be speaking about today.
Interesting. I think the topic, I mean, your topic as a whole, I mean, I think one of the biggest issues that most employers have, I mean, it is, dealing with the employees and how to manage that, right? There's so many facets to what you do. But, for the sake of the topic today, why don't we just jump right into it? And I mean, there's a couple of claims. There's going to be claims regardless, right? But because of COVID, there's a couple of them that are common that a lot of businesses going to expect to see at some point, right? During COVID.
Yeah. So in the employment law world, it was always about compliance with the laws. That was essentially what we advised clients to do. Make sure that they were in compliance with all labor and employment laws as much as possible. And Now, in the midst of COVID-19, the rules are essentially the same. Employers have to stay in compliance with the laws. I'm going to start with what I see as the claims uh, area arising out of COVID-19. So employers are aware now that there's a new law called the Families First Coronavirus Response Act, FFCRA. Um, so that contains essentially two sections. One is the Emergency Family Medical Leave Expansion Act, and the other is the Emergency Paid Sick Leave Act. And both of those new legislations entitle employees to a leave of absence for certain reasons, their own health, serious health condition, and also if their child's school is closed. Um, and the interesting thing about it is that under the EFMLEA, whereby that's, by the way, that expanded the Family and Medical Leave Act, and whereby the Family and Medical Leave Act provided for unpaid leave, the EFMLEA now entitles employees to a paid leave of absence at 2/3 of their pay for a period of time, but employers that are then entitled to take a tax credit for the amount of that the pay received by employees under the EFMLEA. So it's important for employers to be aware of the technicalities under this law, under these laws too. And I'll give you one of the claims we've already seen arising out of a lack of compliance with the FFCRA. So if an employer has laid off employees and then recalls employees, and let's assume some of those employees claim that they can't return because their child's school is closed, and therefore they want to continue on unemployment insurance. Well, the employer still has to offer the employee their right to a leave of absence under the FFCRA, and they have to give them written notice. And if they fail to do so, even though the employee may continue to receive unemployment insurance benefits, the employer is still exposed to a claim by that employee for not receiving their rights, their notice of rights under the EFMLEA. And let's remember that the EFMLEA not only entitles employees to pay, but also to reinstatement rights. If an employee continues on unemployment, they don't have those same reinstatement rights, and they're going to lose certain opportunities. So again, we see that it's important to stay in compliance with these new laws. And by the way, also, I assume many of the listeners are in New York, but New York also passed a paid sick leave legislation as well, which is determined based upon the size of the employer. Another issue we see. Did you have a question, Kyle?
I was going to ask you, are you seeing a lot of those leave claims?
Yeah, we've already seen several. We're already about to start litigating one of them. I want to talk about the leave. When you talk about the leave claims, I'm going to segue into what we also see as another kind of leave claim. This is where an employee may request a reasonable accommodation to accommodate their disability. That's always been the law under the Americans with Disabilities Act, as well as the Family and Medical Leave Act and New York State law. But now employers are faced with employees who are requesting a reasonable accommodation not to return to work, but to continue to work from home. Now, the employee is entitled to a reasonable accommodation to accommodate a disability, but not necessarily to accommodate generalized fears of receiving coronavirus in the workplace. So employers have to be aware that if the request for a reasonable accommodation is made, employers are entitled to ask what the disability is that needs accommodation, what the reasonable accommodation is that is being requested. The employer has to engage in the interactive process, which is having a discussion with the employee to determine whether, for example, working from home is a reasonable accommodation, whether the employee can perform the essential functions of the job in working from home, um, and then whether that accommodation creates an undue hardship to the employer. So this is, we see this, we've already seen a claim that we're involved in, and we expect this to be litigated shortly. But this is something also for employers to be aware of.
Doug,
Yes.
this is a lot for owners and CEOs really keep up with, quite frankly. I mean, most CEOs are not really familiar with all the different legal terms, and to re-educate themselves on what they can and cannot ask and what their responsibilities are. I know that the state has put out some publications and that you want some guidelines, so to speak, to review as far as reopening is concerned. But from your perspective, what is your firm doing to educate your clients on this? Is it based upon their request, or are you guys doing any outreach? Like, how can a business owner be more?
Yeah, we've done an outreach. We've
Mhm,
written some blogs. We've
mhm,
sent them to our clients. We've, offered our assistance. Most of many of our clients have taken us up on that offer. And,
mhm,
it's complicated. It's more complicated than ever because, we've never had in our history mass layoffs on a mass basis, and now we're having mass rehires on a mass basis. And this is a new area. Another example regarding returning to work is that many employers have already laid off a large percentage of their staff. Now they have to, now they will want to offer the employees the ability to return to work. Employers have to be careful that they're not violating the discrimination laws
mhm,
by making those offers. So, for example, the EEOC, the Equal Employment Opportunity Commission, just last week came out with new regulations that prohibits employers from making employment decisions on returning to work based upon their perception of vulnerable employees. So by way of example, if an employer has an employee who's 70 years old, and as we know, listening to the news, a 70-year-old employee may be more vulnerable in the workplace and just out there in society to contract the coronavirus, an employer will be discriminating against that employee if they base their decision not to recall that employee on the employee's age. Same goes for pregnant employees. The employer can't assume that merely because an employee is pregnant that they might be more vulnerable to contracting coronavirus and not offer reinstatement. So again, the laws are changing more quickly than we've ever seen. Before the start of COVID-19, employers essentially were prohibited from asking employees about their disability or about their health condition. And now employers are actually, it's actually promoted in the new regulations that employers can do that, can and should do that. And
mhm,
again, this was intended to spread the virus in the workplace.
mhm,
And again, we see we expect an uptick in discrimination claims.
mhm,
I want to touch upon another area that we expect an uptick in, which is wage and hour claims. We actually expect a surge in wage and hour claims. I'll give you a couple of examples. First of all, for hourly employees are entitled to be paid for all their time. Well, employers may have an issue as to tracking the employee's time when they're working from home. Um, the employers will have that ability to do so, through timesheets and computer and technology issues. but it's still important for employers to be aware that they need to pay the employees for all hours worked. Um, Also, with respect to wage and hour issues, it's important that employers make sure that their employees receive meal periods. In New York, for example, there's a meal period statute entitling employees to a meal period on a daily basis. Well, employers have to come up with some process to track the meal periods to ensure that they're in compliance and to avoid the claims down the road.
Mm-hmm.
Another issue we see in the wage and hour world is um, you could have an employee who was exempt from overtime prior to a layoff. Then you recall that employee, but now you have a reduced staff, and now that employee's duties have changed. And now maybe that employee is performing some exempt duties and some non-exempt duties. And maybe that same employee is now being paid less and is not going to because of cuts in salary. So maybe that employee now is not paid enough to reach the salary threshold. So what we see is, and what we're urging our clients to do, is make sure that they are reassessing the employee's status as exempt versus non-exempt in order to avoid a misclassification issue. Because if they don't, and they continue to treat an exempt employee as exempt, even though their duties and their salary have changed after the recall, then the employer is exposing itself to unpaid overtime claims. So again, I think that's a very important issue to revisit the exempt status of employees.
And
Also, by the way, with respect to wage and hour issues, in New York, for example, employers are required to give their employees notices of pay rates. Well, they probably did that upon hiring, but they're also required to do that upon reducing pay. So employers have to remember that when they recall employees, if the employee's pay is reduced, then they have to issue new wage notices. If they don't, there's actually in a New York statute a $5,000 penalty per employee for failure, potentially $5,000.
are you seeing some of the payroll companies doing it electronically?
Payroll companies
And
are aware of this.
and the PEO company?
Are aware of this. They're trying to, give the same advice to their employers, but
I can imagine if you have 50 or 100 employees, hard to really keep up and track who is what, and so I know a lot of the firms have some electronic, yes.
That's right. One of the questions we've received on several occasions is, what happens if an employee claims that they contracted coronavirus in the workplace? Can we be sued? That's one of the concerns of employers. Well, the answer is that in New York, that the employer can't, and in most states, the employer can't be sued because workers' compensation is the exclusive remedy. And I can also tell you that the workers' comp carriers are taking the position that it's very difficult for an employee to prove that they contracted the coronavirus in the workplace because that same employee, has been to a supermarket or has been to a gas station or has been around other people. And how can you truly prove that the employee contracted a virus in the workplace? So, but that issue is important, and it's that much more important for employers to ensure that they have their workers' comp insurance in place, they have a workers' comp policy, they're complying with the workers' comp policy in order to avoid this issue.
I mean, that could open a whole new can of worms. I mean, if you're not compliant in the workers' comp end, you're definitely going to lose that case.
That's right.
Yeah.
Employers also have to make sure that if they're permitting employees to work from home, that they're taking steps to somehow maintain the employee's privacy, somehow address potential cybersecurity issue, set up a system with their IT department to ensure that their trade secrets are protected. So again, if employers are permitting employees to work from home, it's another issue for them to be aware of. I think that also, yes.
I wanted to transition to safety precautions, but I don't know if you had another uh, common claim that you see might come about as COVID. I was thinking maybe would you see an uptick in wrongful terminations or no
Um, we not, well, we see a potential uptick in discrimination claims. That's,
discrimination?
yes. I just
Mhm.
want to mention, we're in a unique situation in our history. And,
Of course.
when we're dealing with return to work issues, we're dealing with it from a safety and health standpoint and, avoiding liability standpoint. But we're also in a unique time in our world with respect to the recent protests. And what we've also been advising employers to be aware of is that they should make sure that their staff is aware of diversity, that they perhaps receive diversity and inclusion training, that they somehow address their corporate culture to make sure that they're in compliance with that aspect of their policies, that they perhaps come up with a policy to permit employees to, to attend protests if that's what they choose to do. To generally speaking, have a more inclusive environment. So again, in the face of what we're addressing in society right now, it's important to consider that as well. You asked about safety and health protocols in the workplace.
Yeah, some precautions. What some precautions some business owners and CEOs should be aware of, or should be proactive about?
Yeah,
Yeah.
so there should be. It's interesting because this is an area that's essentially in the news every day. If you look at the return to work protocols in New York State, for example, Governor Cuomo has issued what he expects.
Hmm.
He expects everybody to have a written safety plan, every company to have a written safety plan. He expects every employer to have to file certain forms with the Empire State Development Corp.
Yeah.
Um,
Is that going
and
to be enforceable?
um, yeah, why not? I mean, it goes to the issue. It in part goes to the issue of whether employers are taking the proper steps to avoid liability. And I'll tell you right now, what's interesting is that there have been some recent claims arising out of employees claiming that certain employers didn't take proper steps, proper safety and health steps. There are recent lawsuits going through the court system against Amazon and McDonald's, where there's a claim that they didn't take appropriate steps and that they created a hazard to the public. It's essentially a public health hazard, and that's a claim. So
Hmm.
again, from a liability standpoint, it's important for employers to follow safe, to have a written protocol, to follow their safety
We know
protocols.
a whole new world, man. I mean, this, it's a
It is.
lot. It's a lot you
Um,
have to a lot you
and
have to consider.
sure, and needless to say, as everybody knows, take steps to make the workplace more safe.
Hmm.
Employers should have available to employees PPEs. They should recognize social distancing. They should make sure that they have a system in place to report illnesses, to send employees home. Employers should really err on the side of caution. If they hear an employee coughing, send the employee home. There's no reason to take a chance. And again, these are unique times. And if that issue would have come up pre-COVID-19, the employers would have been concerned about a potential disability discrimination claim by sending an employee home under those circumstances. Not anymore. We now err on the side of caution.
And that's up and down from executive level all the way down to um,
That's right.
entry level to the janitors, so
That's
to
right.
speak, right?
Yep. Yep.
Yeah, I mean, it is a gray area too, man. If someone is coughing, right? You know,
Yeah, it could be an allergy.
it could
It
be
could be an
allergy,
allergy.
and the employee too. I mean, you ask them, okay, how are you? Are you okay? Like, what's going on? I mean, normally you wouldn't send someone home or ask them to leave because they're coughing, but now you have to be conscious. I mean, look that. I don't know if you saw the news the other day. It was a bagel store, I think it's in Astoria, and the lady came in the store without a mask and pretty much coughed it into the customer's face.
Right.
Now, that store can be liable because, first of all, everyone in the store should be wearing a mask.
Yeah.
Quite
Yeah.
frankly, so another employee, is that could an employee sue because of that, or what would be their liability in a case like that?
With the bagel store?
The bagel store. So if you're working there and your employer, supervisor, management didn't enforce, and then now you get ill because of it.
Yeah, well, again, there could be a claim, there could be a general liability claim, and again, you're going to have the same issue you had with respect to what I said before about workers' comp claims, which is how is that person going to be able to prove that they contracted coronavirus in that bagel store? I think that they're going to be hard pressed to be able to do that. And again, when I said that employers should err on the side of caution, I don't mean if they hear a cough, send the employee home. I mean, just pay attention to whether there are other symptoms. And again, just, don't ignore it. Just be aware of it. Talk to the employee if necessary, and monitor the situation.
Interesting.
Yep.
Any other significant considerations that companies should be aware of?
Isn't this enough?
Well,
yeah,
I mean,
but no,
I'm thinking about like companies with large offices. Now they have to put up plexiglass and space out the office place, or
yeah,
and then
yeah, I mean,
there's another issue too, that some employees prefer to work at home. So can you force someone to come back into a unsafe environment, or then there's also the bill they have to pay. There's gonna be an expense as well to
yeah, I mean, listen, if the answer is you can't force an employee to come back to an unsafe environment, but
right.
The employer is not going to maintain that they have an unsafe environment. Their position is going to be that they have a safe environment. They put in all the safety protocols. The employee, for example, can work in the office with the door closed, that the employee will be issued a mask that that mask and gloves, and that that there are other physical protocols that have been implemented in the workplace in order to protect the employees. So safety and health, needless to say, is a paramount concern, but employers and employees have to be aware of it as well.
Okay. I mean, this is all great information. I mean, I know you're going to be busy, right?
Yeah. Yes.
You're already busy.
We already are.
You're already busy.
Yes.
I did have one question that came in, and what if a 70-year-old? What happens if the 70-year-old and the pregnant employee request to work from home instead of coming into work? I think we touched on that a little bit.
Well,
right?
I did, but this question is whether they would be entitled to a reasonable accommodation. So the pregnant employee has a disability. So the pregnant employee, you would have to engage in the interactive process, and there's that's a pretty basic scenario, that if that pregnant employee is entitled to perform the essential functions of her job from home, then the employer would likely have to permit it. I don't really see why not. With respect to the 70-year-old employee, the 70-year-old employee doesn't necessarily, doesn't have assuming that the 70-year-old doesn't have a disability, then that request doesn't necessarily have to be accommodated. Again, you'd have to do the same analysis. Is it a reasonable accommodation? Is the employee able to perform the essential functions? But if that employee has generalized fears about returning to work, that's not enough. That's not a disability. So that employee may not have to be granted that reasonable accommodation.
I mean, I think this goes to show, especially, I mean, it was important then, but it's even more so important now that you need to review your policies and your manuals and your guidelines as far as your employee handbooks and the responsibility of what employees are, what each employee is responsible for, and so on is very important. So everyone kind of knows their role, and make sure each employee signs off that they have received it, and you make sure you comply.
Yes, that's another factor that
you know.
employers should review and revise their existing policies.
Yeah, of course, of
Yeah,
course. So Doug, this has been great. There's a
sure.
lot of, there's a lot of, I know I'm definitely going to have you back again. I maybe have, I'll love to have you again when this thing's kind of boils down a little bit. We could probably get some more data and,
Sure.
give you can report more on some of the active cases that you've been involved with since COVID. So
Yeah.
I'll love to have you back.
Okay.
Um,
Thank you, Carl.
appreciate you. So every forum we talk about different topics. The next forum we're going to talk about options available for business owners seeking to exit, and after that we're going to be talking about financing tips and strategies for investors that are looking to acquire businesses, acquire properties, and just do investments in general. So you definitely want to tune in, and definitely want to go to our website. Go to our website. You can learn more about upcoming forums, and Doug, I don't know if you have any upcoming events or webinars or information that you'd like to share with the group, how folks can get a hold of you over at St. Tillman.
I do have another webinar next week, and it's essentially these issues for nonprofits.
Nonprofits.
And
Okay.
there are some unique issues with respect to nonprofits, and we'll be presenting that next week as well. I can post that on the on our website.
Okay, perfect. And when this is being recorded, so by the time this is all produced, you have that. If you can include your information for your webinar next week. In interim, you can visit. What's your website, Doug, and how can folks get a hold of you?
www.sirtillmandallin.com.
Great. And you can also visit the M&Alliance.com, and Doug's contact information is there as well. As well, I want to thank each one of you for attending our webinar today. It will be available on streaming via the various podcast services, as well as YouTube, Facebook, and our website. Thank you again. You've been a great guest, and it's a very timely topic. I'm sure we're going to be talking a lot about this, in the months to come.
Sure. Thanks, Kyle.
Thank you very much, Doug.
Okay.